Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
We're clear? Great. Because what we're about to discuss could save you from a world of hurt. A guy I know, we'll call him David, started a small online business selling custom t-shirts. It was his passion project, his side hustle. Things were going great until he got a letter in the mail. It was a cease and desist. A big company claimed one of his most popular designs was infringing on their trademark. David panicked. He couldn't afford a lawyer. A simple consultation fee felt like a mountain he couldn't climb. So, he did what millions of us do every single day. He went to YouTube. He typed in how to respond to a trademark cease and desist. And he found gold. Or so he thought. He found a video from a super charismatic guy, sharp suit, slick graphics, millions of views. The guy on screen was confident, authoritative. He laid out a step-by-step guide. He even provided a template letter in the description. The advice was simple: be aggressive. Don't back down. Tell them they have no case and that you'll see them in court. The YouTube lawyer said it was a common scare tactic and that 99% of the time the big company would just drop it if you pushed back hard. So David copied the template, filled in the blanks, and fired off an aggressive email. He felt empowered. He felt like he had taken control. For a week there was silence. He thought he'd won. Then the second letter arrived. This one wasn't from a law firm. It was from a federal court. He was being sued. For real. Not for a few $1,000s, but for over $150,000 in damages plus attorney's fees. The aggressive letter hadn't scared them off. It had poured gasoline on the fire. It had demonstrated his willful infringement, which in the world of trademark law, opens the door to massive penalties. That free YouTube advice ended up costing him his business, his savings, and a significant chunk of his future. This story isn't unique. It's happening in different ways to different people all across the country right now. And let's be honest, we all get it. The legal system is a labyrinth. It's confusing, it's intimidating, and more than anything, it is outrageously expensive. The average hourly rate for an attorney in the United States hovers around $300. In big cities for specialized fields, you can easily be looking at $500, $800, even $1,000 an hour. Who can afford that? So when you have a problem, a landlord who won't return your security deposit, a dispute with a contractor, a question about starting a business, what's the first thing you do? You pull out your phone. You type your question into a search bar. And you land on a video. And there they are. The YouTube lawyers. You know the ones I'm talking about. They're polished. They speak with conviction. They break down incredibly complex legal topics into 5-minute, easy-to-digest clips with catchy titles like "The One Word That Will Get You Out of Any Speeding Ticket" or "How to Set Up an LLC and Become Untouchable." They promise secrets the legal profession doesn't want you to know. They make the law seem simple, like a video game with cheat codes. And the appeal is undeniable. It's free, it's on demand, and it feels like you're finally getting an inside scoop. But as you're watching, a little voice in the back of your head starts to whisper, is this guy actually a lawyer? Is this advice for New York or California because the laws are completely different? Is this video from last week or from 5 years ago before that major new law was passed? Is this general information, or is it actual advice I can apply to my very specific, very personal, and very high-stakes problem? You're caught in a paradox. You can't afford the professional, but you can't afford to trust the free alternative. That is the exact problem we are going to solve in this video. My promise to you is this. By the time you finish watching this entire presentation, you will have a rock-solid, foolproof framework for navigating the treacherous waters of online legal information. I'm going to give you the tools to become an intelligent consumer of this content. You will learn how to instantly spot the dangerous red flags that signal you should click away immediately. You'll learn to recognize the green flags that indicate a source might actually be credible and trustworthy. We are going to build your BS detector. You'll understand the crucial difference between legal education, which is what good online content provides, and legal advice, which it can never, ever provide. And most importantly, You will develop the critical judgment to know exactly when to stop searching online and start searching for a real, qualified attorney in your area. This isn't just an academic exercise. The stakes could not be higher. We're not talking about following a bad recipe for a cake. We're talking about your life. Following bad legal advice you found online can lead to you losing your home. It can lead to the destruction of your business. It can lead to you losing custody of your children. It can lead to you signing away your rights in a contract that will haunt you for decades. In the most extreme cases, it could even lead to you ending up in a jail cell. The information is free, but the consequences of getting it wrong can cost you everything. So the central question we're tackling is the one in the title. Can you trust a YouTube lawyer? The answer isn't a simple yes or no. The real answer is, it's complicated. It's a yes, but, and a no, and here's why. And learning to live in that gray area to understand that critical nuance is the single most important skill you can develop to protect yourself in the digital age. It's the key to using the internet as the incredibly powerful research tool it can be, instead of falling into a dangerous trap laid with good intentions and bad information. To get there, we first need to pull back the curtain. We need to understand exactly who these online legal personalities are. They aren't all the same. They fall into distinct categories, each with its own motivations, its own qualifications or lack thereof, and its own level of risk for you, the viewer. We're going to dissect the different archetypes you'll encounter, from the fully licensed practicing attorney who's building a brand, to the law student who's just sharing what they're learning, to the well-meaning hobbyist who just finds the law fascinating, all the way to the most dangerous of all, the outright scammer who is using legal-sounding language to sell you a worthless product or a fraudulent scheme. Understanding who is talking is the first step to deciding whether or not you should listen. So let's start with one of the most fascinating and destructive examples of legal misinformation you can find online: the sovereign citizen movement. You've probably seen the videos. A driver gets pulled over, and instead of handing over their license and registration, they start a bizarre, scripted dialogue with the police officer. They'll say things like, "I am not driving, I am traveling," or "I do not consent to this joinder," or they'll ask the officer for their oath of office. To an outsider, it looks like pure insanity, but to the person behind the wheel, they are executing a brilliant legal strategy they learned from a guru on the internet, a strategy they believe makes them untouchable by the law. This is the ultimate example of why understanding the source of your information is a matter of life and death, or at least a matter of freedom versus a jail cell. The core belief of sovereign citizens is that they, as natural living people, are not subject to the laws of the United States government, which they see as an illegitimate, bankrupt corporation. They believe that through a series of secret legal filings, magic words, and a rejection of things like social security numbers and driver's licenses, they can unplug from the system and become immune to taxes, debt, and even criminal prosecution. Imagine a man, let's call him Dave. Dave is in his late 40s, he's been hit hard by a few economic downturns, and he feels like the system is rigged against him. He's frustrated, angry, and deeply in debt. One night, scrolling through YouTube, the algorithm serves him a video. The title is something like, "The One Secret They Don't Want You to Know About the Law." The man in the video is charismatic, confident, and speaks in a torrent of complex-sounding legal jargon. He talks about admiralty law, the Uniform Commercial Code, and something called the strawman. He explains that when you were born, the government secretly created a corporate entity, a fictional person or strawman, using your birth certificate. All your debts, your taxes, your legal obligations, they all belong to this fictional strawman, not to the real you, the living, breathing man of flesh and blood. And this guru, for a few $100s for his educational packet, can teach you how to separate yourself from your strawman and live truly free. To Dave, this is a revelation. It's not just a legal theory. It's a key that unlocks everything. It explains why he's failed, why he feels powerless. It's not his fault. He's been a slave to a corporate fiction his whole life. He dives in headfirst. He spends weeks watching videos, reading manifestos on obscure forums, and shelling out money for pre-written legal documents covered in red ink, thumbprints, and bizarre punctuation. He's convinced he's a constitutional scholar, a patriot who has discovered the truth. Then comes the test. His car's registration has expired. He doesn't renew it, because a free man traveling on the land doesn't need a corporate license plate. One afternoon he gets pulled over. The blue and red lights flash in his rearview mirror. But Dave isn't scared. He's excited. This is his moment to prove he's right. The officer approaches the window. "Sir, do you know why I pulled you over?" Dave takes a deep breath and begins the script he memorized. I am a natural person, a free man on the land. I am not driving, I am traveling in my private conveyance. I do not consent to this interaction. The officer's friendly demeanor vanishes. His training kicks in. He's no longer dealing with a routine traffic stop. He's dealing with a potential sovereign citizen, which law enforcement agencies classify as a domestic extremist threat due to their potential for violence. The officer's hand rests on his sidearm. He asks for Dave's license. Dave refuses, instead trying to hand him a laminated card that says he's a diplomat from the kingdom of me. He then starts demanding the officer's bond number and oath of office, claiming he's going to place a commercial lien against the officer for millions of dollars for violating his rights. To Dave, he's winning a legal chess match. To the officer, he's watching a man actively obstruct a lawful stop and escalate a simple ticket into a felony. The officer calls for backup. Soon Dave is surrounded. The request to see a license turns into a command to step out of the vehicle. Dave refuses, locking his doors. He shouts through the glass, "You have no jurisdiction over me. I am not the corporate fiction on my birth certificate." The end of this story is always the same. It doesn't end with the police officer apologizing and letting Dave go. It ends with the sound of breaking glass, with Dave being pulled from his car, tossed, and handcuffed. It ends with his car being impounded and with him facing a mountain of charges: resisting arrest, obstruction of justice, driving without a license, driving an unregistered vehicle. In court, he'll try to use his sovereign citizen arguments. He'll declare the judge has no authority, that the flag in the courtroom has a gold fringe, which means it's an admiralty court. And the judge, who has heard this nonsense 1,000 times before, will patiently listen and then sentence him to jail time and fines that are exponentially worse than the original ticket. Dave's life is ruined. He lost his car, his freedom, and thousands of dollars. And the YouTube guru who sold him this fantasy? He's already moved on to the next desperate person, selling the same package of lies, protected by the disclaimer that his content is for educational purposes only and is not legal advice. This is the most extreme end of the spectrum, but it perfectly illustrates the danger. The information Dave consumed was packaged to look like sophisticated legal knowledge. It used real legal terms, cited historical documents out of context, and was delivered with absolute conviction. It created an entire alternate reality with its own language and rules. But this reality shatters the moment it collides with the actual legal system. People don't fall for this because they're unintelligent. They fall for it because it preys on powerful human emotions: desperation, a desire for control, a distrust of authority, and the seductive feeling of possessing secret knowledge. The gurus selling this are masters of psychological manipulation. They create a community, an us versus them mentality, where anyone who questions their theories is just a sheep who hasn't woken up. The YouTube algorithm helps, creating an echo chamber that reinforces these beliefs until they feel like undeniable truth. So when you're evaluating legal information online, the first and most important question you have to ask is, what is the foundation of this person's claims? Is it based on the actual functioning legal system that governs our society? Or is it based on a fantasy, a secret history, or a conspiracy theory? The sovereign citizen movement is an easy one to spot once you know the signs. But what about the information that's more subtle? What about the real estate influencer who's not a lawyer, but gives you a foolproof strategy for asset protection using LLCs? What about the TikTok finance bro who insists you can write off your entire life as a business expense? Or the ex-cop on YouTube who explains criminal procedure, but gets a few critical details wrong? Details that could land you in serious trouble? These people aren't necessarily scammers in the same way the sovereign guru is. They might even be well-intentioned. They believe they're helping. But good intentions don't count in a courtroom. Their advice, which might be 90% correct, can be just as dangerous as the sovereign citizens, because that 10% they get wrong is where your life can fall apart. This is the next category of online legal information we have to dissect: the well-meaning but dangerously unqualified. And their mistakes are much harder to spot. Their videos feel like a public service. They're not selling you gold bars or a magic passport. They're often former paralegals, passionate law students, or most commonly, just regular people who went through a brutal legal fight like a messy divorce or a foreclosure. They came out the other side, battle-scarred but victorious, and now they feel a moral obligation to share their secrets with the world. They position themselves as the David who beat Goliath, and they want to give you their slingshot. The appeal is almost magnetic. They speak your language. They say things like, "I'm not a lawyer and that's my superpower. I haven't been brainwashed by some fancy law school. I know how the system really works on the ground." They build an immediate sense of trust and camaraderie. They're one of us. They're offering what seems like a revolutionary shortcut through a system that feels designed to be confusing and expensive. They'll tell you, "You don't need to spend $10,000 on a lawyer. Just download my ultimate landlord-busting 10-point checklist, $429.95. Feels like a steal. Feels empowering. But this is where the danger creeps in. And it's a far more subtle poison than the sovereign citizen's outright fantasy. The mistakes made by the well-meaning amateur are often hidden in the details, buried in the nuances of the law that they simply don't know exist. And the first and most common fatal flaw is geography. Let's say you're a tenant in Arizona, and your landlord is illegally withholding your security deposit. You're stressed, you're angry, and you go to YouTube for answers. You find a fantastic, high-energy creator. He's charismatic, he's been through it himself, and he lays out a step-by-step plan. He tells you to send a very specific demand letter, quoting a specific statute, and gives you a deadline of 14 days. You follow his advice to the letter. You feel confident, but nothing happens. Your landlord ignores you. When you finally talk to a real lawyer, they tell you the devastating news. That creator was based in Oregon, and in Oregon, the law he quoted is correct. But in your state, Arizona, the law requires a completely different procedure, a different timeline, and references an entirely different set of statutes. Because you followed the wrong advice, you've missed your legal deadline to sue for double damages. Your simple slam-dunk case has evaporated. The well-meaning YouTuber didn't mean to hurt you. He just had no idea that the legal advice he was giving with such confidence was geographically toxic, completely useless, and, in fact, harmful just one state over. The law in the United States isn't one single thing. It's a patchwork quilt of 50 different state laws, countless federal laws, and then an even more complex layer of county and city ordinances. A piece of legal advice that is 100% correct in Miami can be 100% wrong in Milwaukee. The well-meaning amateur, armed with their one personal experience, almost never understands this fundamental truth. They present their local solution as a universal key, and when you try to use it in the wrong lock, it breaks off, leaving you trapped. The second hidden danger is what I call the exception blindness. The law is almost never a simple declarative statement. It's a rule, followed by a long list of unless and except fors. The amateur knows the rule. The professional knows the exceptions. And the exceptions are where cases are won and lost. Think about something like contract law. The amateur will tell you, a contract has to be in writing to be enforceable. They heard it on a TV show, it sounds right, and for some specific types of contracts like the sale of land, it's true. This is called the statute of frauds. But they stop there. They don't know about the dozens of exceptions. They don't know about the concept of promissory estoppel, where you can enforce a promise even without a written contract if someone relied on that promise to their detriment. They don't know about the part performance exception, or the merchant confirmation rule under the Uniform Commercial Code. So you listen to them. Someone made a verbal promise to sell you their classic car for a great price. You spent $2,000 buying specialized parts for it, relying on their promise. Then they back out. You go to the amateur's YouTube channel and they tell you, "Sorry, no written contract, you're out of luck." You give up. You walk away from a case you could have won because you took advice from someone who only knew the first 10% of the rule. They gave you the headline, but the full story, the story that would have gotten your money back, was hidden in the exceptions they never even knew existed. This leads us to the most lethal mistake of all, the procedural trap. The legal system is a game with very, very strict rules. It's not just about what you say, it's about when you say it, how you say it, and what piece of paper you say it on. This is the world of deadlines, filing fees, service of process, and formatting rules. And for the unqualified, this is an uncharted minefield. Let's imagine a man we'll call Mark. Mark is being sued for a credit card debt. He knows he has a good defense. He believes the debt is past the statute of limitations, meaning they waited too long to sue him. He finds a channel run by a legal coach who provides a template for an answer to a lawsuit. The template looks professional. It has all the right sounding phrases. Mark diligently fills it out, explaining his defense, and files it with the court clerk. He feels a huge wave of relief. He's fought back. A month later, he gets a notice in the mail. A default judgment has been entered against him for the full amount of the debt, plus interest and attorney's fees. His bank account is about to be frozen. What happened? The legal coach told him what to file, but not how. The rules in Mark's court required that after filing the answer with the court, he was also legally required to serve a copy on the plaintiff's attorney, and then file a separate document called a certificate of service with the court proving he did it. Because he missed that one seemingly small procedural step, the court considered his answer to be invalid. Legally, it was as if he had never responded at all, so the other side won automatically. Mark's defense was perfect. He was right on the law. But he lost his entire case and a lot of money because of one procedural detail his YouTube guru knew nothing about. This happens every single day. People with winning cases lose them not on the merits, but on a technicality they never saw coming. The well-meaning amateur gives you a sword, but they don't tell you the duel is happening on a tightrope over a pit of fire. The psychological pull of these creators is immense. They tap into our desire for a simple, just world where a little bit of common sense and a fighting spirit can overcome a complex system. Their confidence is contagious. But it's often a classic case of the Dunning-Kruger effect. They have just enough knowledge to be confident, but not enough to know how much they don't know. Their comment sections become self-reinforcing echo chambers. Anyone who posts, "Hey, I'm a lawyer and this is incorrect in Ohio," is immediately attacked by a mob of followers. You're just scared of losing your job. Stop trying to gatekeep justice. This creates a powerful cult-like atmosphere where the guru's word is treated as gospel, and any outside criticism is dismissed as an attack from the corrupt establishment. So you've learned to spot the grifters, you can see the sovereign citizen's flawed logic from a mile away. And now you know the hidden dangers of the well-meaning amateur. The obvious solution, then, seems simple: just listen to the creators who are actual licensed attorneys, right? They have the JD after their name, they've passed the bar. They must be safe. Unfortunately, the answer is a minefield of its own. And that's where we find our third, and perhaps most deceptive category of online legal guide. This is the world of the licensed lawyer influencer. These are the big guns. The ones with the fancy diplomas on the wall, the slick suits, and the charisma of a seasoned trial attorney charming a jury. They are, by all technical definitions, real practicing lawyers. They've gone to law school, they've passed the bar, often in a major state like California or New York, and they have a deep understanding of the legal system. And that, right there, is what makes them so profoundly dangerous. Because the advice they give isn't necessarily wrong. In fact, it's often technically correct. But it's presented in a way that is stripped of the single most important element of any legal guidance: context. Your context. Every single legal problem is a unique universe of facts. It's a complex tapestry woven from who you are, where you live, what you did, what the other person did, the specific words on a specific page, and the precise timing of every event. A real lawyer, one you hire, spends most of their time not reciting the law, but painstakingly gathering and analyzing the unique facts of your case. They ask dozens, sometimes hundreds, of questions to understand your universe. The YouTube lawyer, on the other hand, can't do that. They are broadcasting a single generic message into millions of different universes at once, and the result can be catastrophic. Let's talk about Mark. Mark was a brilliant freelance web developer from Arizona. He was starting to get real traction, landing bigger and bigger clients. Finally, he got his dream gig. A 6-month contract with a hot new tech startup based in San Francisco. They loved his portfolio and sent over an independent contractor agreement. It was a dense 15-page document filled with intimidating legal jargon. Mark felt a knot in his stomach. He couldn't afford a lawyer to review it. They quoted him nearly $1,000. But then he remembered a YouTube channel he loved. Let's call the host Justice Jack. Justice Jack was a fast-talking, super confident lawyer from California. He had millions of subscribers. His videos had titles like 5 contract red flags that will ruin your life and how to negotiate like a shark. Mark found a video specifically about freelance contracts. Justice Jack, standing in front of an impressive law library, confidently broke it down. He said, "Folks, you have to watch out for the indemnification clause. Make sure it's mutual. And your intellectual property clause has to be crystal clear about who owns what after the project is done. Finally, always have a clear termination for convenience clause, so you can get out if the client is a nightmare." The advice was clear, concise, and empowering. Mark felt a wave of relief. He opened his 15-page contract and, using Justice Jack's video as his guide, went hunting. He found the indemnification clause, it looked mutual. He found the intellectual property clause. It said he'd retain ownership of his pre-existing IP. and the company would own the final deliverables. Seemed fair. He even found a termination clause. Check, check, and check. Feeling confident, Mark signed the contract and got to work. For 5 months things were great. He built a revolutionary new platform for the startup. But in the final month, communication went dark. Payments stopped. Then he got an email from the startup's new C-suite. They were terminating his contract, and by the way, they were asserting ownership over not just the final website, but the proprietary code framework Mark had spent 3 years developing on his own time, long before he ever met them. How? Buried deep in the contract wasn't a standard intellectual property clause, but a viciously clever assignment of inventions clause. It stated that any and all intellectual property, conceived, developed, or reduced to practice during the term of the agreement was the sole property of the company. Because he had used and improved his own framework during the contract, they argued they now owned it entirely. Justice Jack never mentioned an assignment of inventions clause. Why would he? It's a more niche, aggressive clause not found in most standard freelance agreements. But it was in Mark's. Devastated, Mark called a lawyer in Arizona for a consultation. The lawyer listened grimly and then delivered the final blow. Mark, this is bad. But it gets worse. You see this governing law and venue clause on page 14? It says any and all disputes arising from this contract must be litigated in the Superior Court of California in San Francisco. Mark lived in Phoenix. The cost of hiring a California lawyer, filing a lawsuit in a different state, and flying back and forth for court dates would be tens, if not hundreds of thousands of dollars. The startup knew this. They had trapped him. He was financially and geographically checkmated. He lost everything, his final payment, and the code framework that was the foundation of his entire business. So what went wrong? Was Justice Jack a bad lawyer? Did he give bad advice? No. His advice was perfectly fine, generic B+ advice for a general audience. The problem is, Mark didn't need general advice. He needed specific legal counsel. He needed a professional who was bound by a duty of care to him, who would read every single line of his contract, and who understood the laws and legal landscape of his situation. This highlights the 3 silent killers lurking behind every YouTube lawyer video. First, the jurisdiction trap. Law is not universal. It is a patchwork quilt of federal, state, and even local city ordinances. A contract clause that is perfectly legal and enforceable in Texas might be deemed unconscionable and illegal in California. A piece of real estate advice that's gospel in Florida could get you sued in New York. The YouTube lawyer is almost always speaking from the perspective of the laws in the single state where they are licensed. But their audience is in all 50 states and around the world. They are, by definition, giving advice that will be contextually wrong for the vast majority of their viewers. Second is the false security trap, which is what happened to Mark. Watching a 15-minute video made him feel like he had conducted a thorough legal review. It armed him with just enough knowledge to be dangerous. He learned to spot a few common lions and tigers, but he was completely blind to the venomous snake hiding in the grass, the one specific to his contract. The video gave him the confidence to walk into a minefield, but not the map to navigate it. And third, perhaps the most overlooked danger, is the time decay trap. The law is not static. It changes. Every single year, new statutes are passed by legislatures, and new precedents are set by courts. A video made in 2020 about, for example, the rules for starting a small business as an LLC might contain information that is now dangerously out of date. Tax laws may have changed. Filing requirements may have been updated. But the video is still on YouTube, racking up views, presented by the algorithm as fresh, relevant advice. There's no expiration date stamped on it. It's a digital time bomb, waiting to go off in the hands of an unsuspecting viewer who thinks they're getting cutting-edge information. These licensed lawyer influencers aren't an alternative to hiring a lawyer. They are a marketing funnel. Their videos are advertisements designed to build their brand, sell their books, or get you to click the link in their description to their firm. They provide immense value in one area, making you aware that a legal issue exists. They can be a fantastic starting point for your education. They can help you formulate the right questions to ask. But they are the beginning of your journey, not the destination. Believing otherwise is like thinking that watching a video about how a surgeon performs an appendectomy qualifies you to operate on yourself. The tools might look simple, but without a lifetime of training and a deep understanding of the specific anatomy in front of you, a disaster is not just possible, it's inevitable. And this is where the entire universe of online legal advice begins to crumble. Because the law, unlike medicine, isn't governed by a single universal anatomy. The human body is the human body, whether you're in Miami or Montana. But the body of law? It changes drastically the second you cross a state line. Sometimes it changes when you cross a county or even a city line. This is the single most dangerous, most misunderstood, and most catastrophic pitfall of trusting a YouTube lawyer. The absolute chaos of jurisdiction. Jurisdiction is just a fancy word for who has the power to make and enforce the law in a certain geographic area. In the United States, we don't have one legal system. We have 51 major ones, the federal system, and one for each state. And within those states, you have countless local rules, ordinances, and court procedures. It's a complex, overlapping, and often contradictory patchwork quilt of regulations. A YouTuber, no matter how brilliant or well-intentioned, is broadcasting from their one little patch on that quilt, but their advice is being heard by people sitting on thousands of other, completely different patches. Let's make this real. Imagine you're a landlord in Austin, Texas, and you have a tenant who hasn't paid rent in 3 months. You're frustrated. You go to YouTube and find a video from a very popular, very confident real estate lawyer with millions of views. He's based in New York City. He tells you, look, in a situation like this, the law in many places allows for what's called self-help eviction. You can change the locks, you can remove their belongings to a storage unit, and you can shut off the utilities to get them out. It's fast, it's effective. So you listen. You change the locks. You turn off the water. The next day, you don't get a moving truck. You get a visit from the Austin police. You're being charged with multiple misdemeanors, including coercion and illegal lockout. Why? Because while some form of self-help might have been permissible under very specific old New York statutes he was vaguely referencing, in Texas, what you just did is completely and utterly illegal. The Texas Property Code explicitly forbids it. Not only are you now facing criminal charges, but your tenant can sue you for damages, including a civil penalty of 1 month's rent plus $1,000, actual damages, court costs, and attorney's fees. Your attempt to solve a problem by following viral advice has now spiraled into a legal and financial nightmare that could cost you tens of thousands of dollars and a criminal record. The YouTube lawyer in New York faces 0 consequences. You face all of them. This isn't a rare, 1 in a million scenario. This happens every single day in every single area of law. Let's talk about divorce. It's an emotional minefield, and people are desperate for guidance. You might watch a video from a lawyer in California, a state known as a community property state. They'll explain that, with few exceptions, everything earned or acquired during the marriage is considered owned 50-50 by both spouses. The house, the cars, the retirement accounts split right down the middle. Sounds simple, fair. But you live in Georgia, or Florida, or Pennsylvania. You live in one of the 41 states that use a system called equitable distribution. The word equitable does not mean equal. It means fair. And a judge in an equitable distribution state has enormous discretion to decide what is fair. They'll look at the length of the marriage, the earning capacity of each spouse, who is the primary caregiver for the children, who has a greater need for the marital home, whether one spouse was a homemaker who sacrificed their career, and even things like marital misconduct in some states. So you, living in Georgia, march into your divorce negotiation armed with California community property knowledge from YouTube. You demand 50% of everything, period. You refuse to negotiate. You think you're standing up for your rights. In reality, you look completely unreasonable to the judge and the opposing attorney. You've poisoned the well for any amicable settlement. You've based your entire life-altering financial strategy on a legal principle that, for you, might as well be from another planet. The judge, following Georgia law, might decide that an equitable split is 65/35, or that one spouse gets the house outright. By following the wrong map, you didn't just get lost, you drove your own case right off a cliff. And it gets even more granular and more dangerous. Let's talk about the silent killer of legal cases, the statute of limitations. This is the absolute, non-negotiable deadline for filing a lawsuit. If you miss it by 1 day, your case is dead on arrival. It doesn't matter how badly you were wronged or how much evidence you have. Your claim is extinguished forever. And these deadlines are a jurisdictional minefield. Let's say you're in a serious car accident. For a personal injury claim, the statute of limitations in Maine is 6 years. In California, it's 2 years. In Kentucky, it's 1 year. In Louisiana, for many claims, it's also a brutally short 1 year. Now imagine you live in Nashville, Tennessee. You get into a wreck and suffer a back injury. You're in pain, you're dealing with doctors and physical therapy. You don't have the energy to think about a lawsuit yet. You watch a few videos from a big-name YouTube lawyer who happens to be based in Chicago, Illinois, where the statute of limitations for personal injury is 2 years. He casually mentions the 2-year rule in a video. You internalize that. You think, okay, I've got plenty of time. I'll focus on my recovery. You wait. You get better. A year and 2 months after the accident, you finally feel ready to act. You call a local Nashville attorney. You tell them your story, ready to seek justice. And then comes the gut-wrenching silence on the other end of the phone. The lawyer has to tell you that the statute of limitations in Tennessee is only 1 year. You missed the deadline by 2 months. Your case, which might have been worth hundreds of thousands of dollars to cover your medical bills and lost income, is now worth exactly 0. Your legal rights have evaporated into thin air. All because you applied a rule from Illinois to a case in Tennessee. The YouTube lawyer didn't lie to you. He just gave you information that was correct for him and catastrophically wrong for you. Even beyond these bright-line rules like statutes and property division, there's a deeper, more subtle layer of law called precedent. This means that the law isn't just the statutes written by politicians. It's also the collection of all the decisions made by higher courts in your specific jurisdiction. A judge in Ohio is bound by the decisions of the Ohio Supreme Court and the Federal Sixth Circuit Court of Appeals. They could not care less about a landmark ruling from the Ninth Circuit in California or the Texas Supreme Court. A YouTube lawyer might get incredibly excited about a brand new ruling in their state that changes everything about how, say, digital evidence from a cell phone is handled in a criminal case. They make a viral video titled, "This ruling changes everything." And for them, in their jurisdiction, it does. But if you're a defendant in another state, that ruling has the same legal weight as a comic book. It's irrelevant. Your local lawyer, however, knows the key precedents in your jurisdiction. They know the quirky, specific rulings from your state's appellate court from 1987 that still govern your case. They know how Judge Smith in your local courthouse tends to interpret that precedent. This is the nuanced, hyperlocal, three-dimensional chessboard of law. A YouTube video is a flat, one-dimensional picture of a single square on that board. A square that you probably aren't even playing on. Let's take that chessboard. You're trying to learn the game, so you watch a YouTube video titled, "The One Move That Wins Chess Every Time." The creator shows you a brilliant 4-move checkmate called Scholar's Mate. It's simple, it's elegant, and it works flawlessly in the video. You memorize it. You feel powerful, like you've unlocked a secret code. You sit down to play a real game, execute the 4 moves perfectly, and your opponent doesn't do what the person in the video did. They don't fall into the trap. Instead, they see your amateurish attack coming a mile away, easily defend it, and in the process they develop their pieces, control the center of the board, and leave your queen dangerously exposed. You didn't just fail to win, you put yourself in a losing position from the very start. The video didn't teach you how to play chess. It taught you a single rigid sequence that only works against a specific and frankly foolish response. The video gave you a tactic, but it gave you zero understanding of the strategy, the principles, or the board itself. Now let's replace the chessboard with the legal system, and the Scholar's Mate with online legal advice. Meet Sarah. Sarah is an incredibly talented graphic designer who has a side hustle drawing custom pet portraits. It's taking off. She's getting more orders than she can handle, and she realizes this could be her full-time job. She's excited but also terrified. She knows she needs to make it official, to protect herself and her assets in case something goes wrong. What if someone claims she stole their dog's likeness? What if she has a dispute with a supplier? Her first thought isn't to call a lawyer. That sounds expensive and intimidating. Her first thought is to go to YouTube. She types in how to start a small business. The algorithm blesses her with a video from a channel called Lion of Law. The host is a charismatic guy in a sharp suit, sitting in front of a bookshelf filled with impressive-looking law books. His video is titled, "The Number 1 Mistake New Entrepreneurs Make and How to Avoid It." It has 2 million views. The host, let's call him Leo, speaks with absolute confidence. He says the biggest mistake is operating as a sole proprietor. He says you need an LLC, a limited liability company, to create a corporate veil that protects your personal assets, your house, your car, your savings, from any business debts or lawsuits. So far so good. That's generally true. But then Leo gets specific. He says, folks, don't just form any LLC. The pros, the big corporations, they know the secret. You want to incorporate in a state with the strongest business protections and the most favorable laws. and the gold standard, the undisputed champion, is Delaware. He spends the next 10 minutes extolling the virtues of the Delaware LLC. He talks about its special business court, its privacy protections, its prestige. He makes it sound like if you form your LLC anywhere else, you're a complete amateur. He even has a helpful link in his description to a website that will form your Delaware LLC for you for a low flat fee. Sarah is sold. She lives and works from her apartment in California, but Leo made it sound like that doesn't matter. This is for her online business, so it seems modern and sophisticated to have it based in the best state. She clicks the affiliate link, pays the fee, and a week later, she receives a digital folder with all the official-looking documents for Positively Portraits LLC, a legally formed entity in the state of Delaware. She feels a huge wave of relief. She's a real business owner now. She's protected. She's done it the smart way, the way the pros do it, and it only cost her a few $100. For the first year, everything is great. Business is booming. She's making more money than she ever did at her old job. She files her taxes, claiming her business income, and everything seems fine. Then, about 14 months after she formed her Delaware LLC, a letter arrives. It's from the California Franchise Tax Board. The envelope looks menacing. Inside, it says she has failed to pay her annual franchise tax. It's a bill for $800, plus another $200 in penalties and interest. $1,000. Sarah is stunned. What franchise tax? She doesn't own a McDonald's. She draws pictures of cats in her spare bedroom. Panicked, she goes back to Leo's channel, Lion of Law. She searches for California franchise tax. Nothing. Delaware LLC taxes. He has a video, but it's all about the benefits of not having to pay state income tax in Delaware if you don't do business there. It doesn't mention anything about your home state. She posts a frantic comment on his original video. Help! I formed a Delaware LLC like you said, but I live in California and just got a $1,000 tax bill. What do I do? Her comment is buried among thousands of others praising Leo for his brilliant advice. He never replies. A few weeks later, a second letter arrives. This one is from the California Secretary of State. It's a notice of failure to qualify. It says her company, Positively Portraits LLC, has been illegally transacting intrastate business without being registered. The letter mentions more penalties are forthcoming. Now Sarah is in a full-blown panic. This legal shield she thought she had built is turning into a cage. After a sleepless night, she does what she should have done in the first place. She pays for a 1-hour consultation with a local California business attorney. The lawyer listens patiently and then gives her the bad news. The advice from Lion of Law wasn't necessarily wrong. It was catastrophically incomplete. For a massive company that operates nationwide, incorporating in Delaware might make sense. But for Sarah, a solo entrepreneur living and working in California, it was the worst possible choice. The lawyer explains that because her business is physically operating in California, because she is in California, she is required by law to register her Delaware LLC as a foreign entity with the California Secretary of State. This process involves its own fees and paperwork. More importantly, by registering to do business in California, she is subject to all of its regulations and taxes, including the infamous $800 minimum annual franchise tax that every LLC has to pay, regardless of whether it makes a profit. So by following the YouTuber's advice, Sarah didn't avoid California's rules. She just added another entire layer of complexity and cost on top of them. She now has to pay fees and file annual reports in both Delaware and California. She has to comply with the laws of 2 different states. The simple, cheap solution has doubled her administrative burden and her annual costs. And that's before all the penalties she now owes for failing to do any of this for over a year. The lawyer estimates it will cost her several $1,000s just to get compliant and clean up the mess. It would have been cheaper, simpler, and faster to just form a basic California LLC from day one. Sarah's story is the perfect storm of why you can't trust a YouTube lawyer. Leo, the Lion of Law, is incentivized by the YouTube algorithm to create content for the largest possible audience. The secret to forming a Delaware LLC is a sexy, clickable title that appeals to aspiring entrepreneurs in all 50 states. A video titled A Nuanced Guide to Entity Selection for California-Based Artisans Earning Under $100,000 Annually would get about 12 views. The algorithm punishes specificity. It rewards broad, sweeping generalizations. Furthermore, Leo has no relationship with Sarah. He has no duty to her. A real lawyer is bound by a code of ethics. Their primary duty is to their client. Their first questions would have been, where do you live? Where do your customers live? What kind of business is it? Leo can't ask those questions. He's not giving legal advice to an individual. He's creating infotainment for a mass market. And let's not forget that affiliate link. Leo likely gets a commission for every person who, like Sarah, signs up to form a Delaware LLC through his link. His advice isn't just shaped by the YouTube algorithm. It's shaped by his own financial incentives, which may not align with what's best for his viewers. He's not selling legal counsel. He's selling a product. Sarah's disaster was born from advice that was technically correct in a vacuum but practically disastrous when applied to the real world. It was a jurisdictional mismatch, a classic case of applying a one-size-fits-all solution to a problem that is, by its very nature, hyperlocal. But her story is about a mistake, about incomplete information. What happens when the information isn't just incomplete? What happens when it's a deliberate, calculated lie? When the YouTube lawyer isn't just a misinformed content creator, but an active predator selling a fantasy that will not just cost you money, but could land you in a real-life courtroom, or even jail. That's where we go next. Into the shadowy world of sovereign citizens, tax protesters, and legal scams that prey on the desperate and the angry. This corner of the internet is a graveyard of broken lives, built on a foundation of pure fiction. It starts with a seductive promise. What if the entire legal system was a lie? What if you, and only a select few, knew the secret cheat codes to unlock true freedom? This is the core belief of the sovereign citizen movement, an ideology that has been supercharged by social media algorithms. The central fantasy goes something like this. When you were born, the government secretly created a corporation, a legal fiction, using your name in all capital letters. This is what they call the strawman. That's the entity with the driver's license, the social security number, the bank accounts. But you, the theory goes, are a flesh and blood living man or woman, a sovereign being who is not subject to their corporate laws unless you consent. You see it play out in thousands of viral videos. A car is pulled over, and the driver refuses to provide a license, stating, "I'm not driving, I'm traveling." They'll hand the officer a homemade ID card, refuse to get out of the car, and declare that the officer has no jurisdiction over them. They'll cite obscure maritime law or sections of the Uniform Commercial Code, believing these are the real rules that govern the country. To them, it's a heroic stand against tyranny. To the police officer, it's a Tuesday. Online gurus, often with no legal training whatsoever, sell this fantasy in expensive seminars and packets of pre-written, nonsensical legal documents. They'll teach you the magic words to say to a judge, the special way to sign your name with red ink, or how to file a common law lien against a government official for billions of dollars. They create an echo chamber, a community of believers who reinforce these ideas, sharing videos of their wins, which are usually just a confused officer letting them go with a warning to avoid a prolonged roadside argument, while ignoring the catastrophic losses. And the losses are always catastrophic. Let's trace the path of someone who gets sucked in. It begins with something small, a simple speeding ticket. Frustrated, they go online and find a video titled, "Never Pay a Traffic Ticket Again." The guru in the video seems confident, knowledgeable. He explains the strawman theory. It sounds crazy but also empowering. So, our person buys the $100 document packet and marches into court. When the judge calls their name, John Smith, they stand up and declare, "I am not John Smith the legal fiction, I am John of the family Smith, a living man, here by special appearance." The judge sighs. The bailiff shifts his weight. The prosecutor barely looks up from their phone. This is not the first time they've heard this. It won't be the last. The judge asks for their plea. They respond by questioning the court's jurisdiction and demanding the judge produce their oath of office. This is where the fantasy collides with reality like a train hitting a brick wall. The judge doesn't engage in a debate about maritime law. Why? Because every single one of these arguments has been tried, tested, and rejected by every court in the country for decades. They are legally defined as frivolous. The judge, whose patience is finite, will enter a not guilty plea on their behalf to move things along, or more likely, will find them in contempt of court for disrupting the proceedings. The simple speeding ticket, which could have been resolved with a $100 fine, now spirals. The contempt charge adds another fine, maybe even a night in jail. They refuse to cooperate, so their license gets suspended. They keep traveling, get pulled over again, and are now arrested for driving on a suspended license. They try the same arguments with the new, more serious charges. The fines pile up. The jail time gets longer. They've taken a tiny problem and, by applying this fantasy legal theory, have systematically dismantled their own life. They lose their job, their car gets impounded, and they end up with a criminal record. All because a YouTube guru told them they knew a secret the rest of the world was too foolish to see. A close cousin to the sovereign citizen is the tax protester. The sales pitch is just as alluring. The income tax is unconstitutional and voluntary. You don't have to pay it. Gurus will point to the 16th Amendment, claiming it was never properly ratified. They'll argue that your wages aren't income in the legal sense, but rather an equal exchange of property, your labor for their money. Sounds technical. Sounds plausible if you don't know any better. They sell books and courses promising to free you from the tyranny of the IRS. Let's follow this path. An entrepreneur frustrated with their tax bill watches a few of these videos. They pay a guru $1,000 for a kit on how to legally stop paying federal income tax. For the first year, it feels like a miracle. They have thousands of extra dollars. They feel brilliant, like they've beaten the system. The second year, same thing. But the IRS isn't a person you can out-argue. It's a vast automated bureaucracy. It notices. First come the letters, gentle reminders, then increasingly stern warnings. The tax protester, coached by their guru, sends back bizarre, rambling responses filled with legal-sounding gibberish, declaring their sovereignty and refusing to pay. The IRS ignores these letters. Instead, it moves to the next step. A federal tax lien is placed on their property. Then comes a levy on their bank accounts. One morning, they wake up and their life savings are gone. Then their wages are garnished. A huge chunk of their paycheck starts disappearing before they ever see it. Finally, when the debt is large enough, the case gets handed to the Criminal Investigation Division. Now it's not just about money, it's about freedom. They are indicted for tax evasion. In court, they try the same arguments their guru taught them. And just like in traffic court, the judge has heard it all before. The arguments are dismissed as frivolous. They are found guilty. Now, not only do they have to pay all the original back taxes, but also staggering penalties for fraud and failure to file, plus interest that has been compounding for years. And on top of that financial ruin, they are sentenced to years in federal prison. The guru who sold them the idea is either in prison themselves or has long since vanished with their money. Why do people fall for this? Because it offers a sense of power to the powerless. It feeds on a deep-seated and sometimes justified distrust of authority. It provides simple, magical answers to complicated, frustrating problems. It's not just a legal theory, it's an identity. You're not a sucker paying taxes like everyone else. You're an enlightened patriot who knows the truth. But this truth is a mirage, and the oasis is a prison cell. These are not harmless eccentrics. They are peddlers of a life-destroying ideology, and their legal advice is a one-way ticket to disaster. But this is the extreme end of the spectrum. The danger online isn't always this obvious. It doesn't always wear a tinfoil hat. What about the advice that sounds reasonable? The videos that aren't about overthrowing the government, but about simple, everyday legal problems? The one weird trick to get out of a lease, the DIY will and trust kits, the step-by-step guide to representing yourself in small claims court. This is where the lines get blurry, and where millions of well-meaning people are led astray, not by fantasy, but by plausible-sounding half-truths. That's the gray area we need to explore next. This gray area is the most dangerous part of the entire online legal landscape. It's not the sovereign citizen shouting nonsense or the fake lawyer promising the moon. It's the well-produced, confident, and often genuinely knowledgeable creator who gives you a roadmap that leads directly off a cliff. And the first, most common pitfall on that map is what I call the jurisdiction trap. Every single legal issue you could ever have is governed by a specific set of rules. We call this jurisdiction, but it's not just about what state you're in. It's about what county, what city, what specific court. The law isn't a single book. It's an infinite library where every shelf is for a different town, and the books are constantly being rewritten. A YouTube lawyer in California might make an excellent video about landlord-tenant law. They'll explain statewide eviction rules, notice periods, and security deposit regulations. You, a renter in San Francisco, watch this video. You feel empowered. You've got this. You follow the advice to the letter, and you lose. Horribly. Why? Because the video never mentioned the San Francisco rent ordinance. a hyper-specific, notoriously complex set of local laws that override state law in dozens of critical ways. Your notice period was wrong. Your reason for eviction wasn't valid under the local code. The advice wasn't wrong. It was just catastrophically incomplete for your specific location. It's like getting directions from someone who says, "To get to the White House, just go to Washington, D.C." That's true, but it's useless. You need to know the street, the address, the quadrant. The law is 1,000 times more granular. A video about how to fight a traffic ticket might be based on Arizona law, where a police officer's visual speed estimate is given less weight. You try that same argument in Virginia, and the judge might laugh you out of court because their state precedent says an officer's training and experience is perfectly sufficient. The YouTube creator isn't lying to you. They're just describing their own backyard, while you're standing in a completely different forest. This single issue, the failure to account for local rules, ordinances, and court precedents, is responsible for countless self-represented litigants getting their cases dismissed before they even get to argue the facts. They followed the viral video's advice and walked straight into a jurisdictional wall. But even if you manage to find a video that applies to your exact city and state, you're immediately faced with the second, more insidious problem: the procedural pitfall. The law is not just a set of ideas, it's a machine. A very old, very complicated machine with a precise sequence of levers you have to pull in the right order. Procedure is the instruction manual for that machine. It's the boring, tedious, non-glamorous stuff that never makes it into a YouTube thumbnail. It's about deadlines, filing fees, specific form numbers, font sizes, and how many paper clips you need on a document. It's the stuff that makes or breaks cases. Let's imagine a small business owner, we'll call her Sarah. A client owes her $10,000 for a project she completed. The client is ghosting her. Frustrated, Sarah turns to YouTube. She finds a channel run by a business lawyer who explains a powerful tool called a motion for summary judgment. The video explains that if the facts aren't in dispute, you can ask the judge to just rule in your favor without a full trial. It sounds perfect. The facts are clear. She did the work, the client signed the contract, the client didn't pay. Feeling confident, Sarah spends a weekend drafting a beautiful, persuasive document she calls Motion for Summary Judgment. She lays out all the facts, attaches the contract, the emails, everything. She files it with the court. A few weeks later, she gets a notice in the mail. Her motion was denied. Not because her argument was bad, but because it was procedurally deficient. What the 10-minute YouTube video didn't tell her was that in her state, Rule of Civil Procedure 56C requires that a motion for summary judgment must be filed with a separate statement of undisputed material facts, and that each fact must be numbered and cross-referenced to a specific piece of evidence attached as a lettered exhibit. It also didn't mention that she had to serve the motion on the opposing party via a specific method, and then file a certificate of service with the court clerk within 3 days, attesting that she did so. She did none of that. She just filed her document. To the court, it was the legal equivalent of submitting a handwritten letter in crayon. The machine rejected it. The judge never even read her brilliant argument. She lost her chance at a quick victory, wasted weeks of time, and now looks incompetent to the court, all because she didn't know the rules of the road. This happens every single day. Someone watches a video about how to sue someone in small claims court. The video says, just fill out the complaint form and file it. But it doesn't tell you that your local court requires you to also fill out a case information sheet, a summons, and a civil cover sheet, and that if you fail to serve the defendant properly within 60 days, your case is automatically dismissed. The procedure isn't a suggestion, it's the entire game. And it's the part that online content almost always glosses over because it's specific, complex, and frankly boring. Finally, we arrive at the most subtle and perhaps most profound problem: the context collapse. A real lawyer in a real consultation spends most of their time asking you questions. They are mining for context. When did this happen? Who was there? What did you say exactly? What did they say? Have you spoken to them since? Is there anything in writing? They are trying to assemble a three-dimensional picture of your situation. A YouTube video can't do that. It exists in a two-dimensional world. It takes a common problem, collapses all possible context, and offers a single clean solution. The video is titled, "Your Boss Can't Legally Do This." It explains that under federal law, it's illegal for an employer to retaliate against you for reporting a safety violation. That is a true statement of law. You, having just been fired a week after you reported an unsafe piece of machinery, watch this and think you have a slam dunk lawsuit. You file the suit yourself. Then, in the discovery process, your employer's lawyer produces your employee file. It shows you were late to work 17 times in the last 2 months. You had 2 formal written warnings for poor performance, both of which you signed. And there's an email from your supervisor to HR, dated 3 weeks before you reported the safety violation, recommending your termination for poor attendance. Suddenly, the context changes everything. Your case is no longer a simple story of a brave whistleblower being silenced. It's a messy story about a poor-performing employee who might be trying to use a safety complaint as a shield. Maybe you'd still win, maybe not. But the clean, simple narrative from the YouTube video has completely dissolved. A real lawyer would have uncovered this context in the first 5 minutes of talking to you and given you a much more realistic assessment of your chances. They would have told you that the timing is suspicious, but your performance record is a huge hurdle to overcome. The YouTube video couldn't do that. It flattened your reality. It collapsed the context and sold you a simple story that was true, but not the whole truth of your situation. These 3 issues, the jurisdiction trap, the procedural pitfall, and the context collapse, are not the fault of evil or incompetent creators. They are fundamental limitations of the medium itself. You cannot provide personalized, actionable legal advice in a one-to-many broadcast format. It's impossible. The result is that millions of people are armed with a dangerous level of false confidence. They've been given a few puzzle pieces and think they see the whole picture. They're ready to march into a complex adversarial system, unaware that the map they're holding is missing all the mountains, rivers, and landmines. So if general how-to legal advice is a minefield, what about the other major category of legal YouTube? The channels that simply react to real court cases or analyze legal news. They aren't telling you what to do. They're just commenting on what's happening, right? Surely that has to be safe. Well, this is where a different, more subtle kind of distortion takes root, one that doesn't just risk your individual case, but shapes our entire collective perception of how justice actually works. Let's call this the highlight reel effect. Think about it like Instagram. You scroll through a feed of your friends' greatest moments. The perfect sunset on a beach in Bali, the celebratory dinner for a big promotion, the flawlessly curated photo of their newborn. What you don't see is the mountain of laundry, the argument over bills, or the 3 a.m. feeding where everyone is exhausted and crying. You're seeing the 1% of life that is spectacular, and if you're not careful, you start to believe that's what 100% of life is supposed to look like. YouTube law is the Instagram of the legal profession. We see the mic drop moment in a cross-examination, the shocking last-minute evidence reveal, the impassioned closing argument that sways the jury. We see the triumphant press conference on the courthouse steps after a billion-dollar verdict. What we don't see are the preceding 2,000 hours of paralegals sifting through a warehouse of documents, one by one. We don't see the 100-page motion on a tedious point of civil procedure that took a junior associate 3 weeks to write, and will never be mentioned in a video. We don't see the endless, grinding, mind-numbingly boring depositions where lawyers spend 8 hours asking questions like, "And when you sent the email on Tuesday, was it before or after you had your lunch?" The truth, the unsexy and unviral truth, is that the vast majority of legal work is a slow, methodical, administrative grind. Over 95% of civil and criminal cases in the United States never even reach a trial. They are settled, dismissed, or resolved through plea bargains long before a jury is ever selected. The legal system isn't a boxing match of dramatic knockouts. It's a marathon of paperwork. But because we are fed a constant diet of the highlight reel, our expectations become warped. A person gets into a minor fender bender and, having binged videos of lawyers taking on corporate giants, walks into their local attorney's office with a list of Hollywood-inspired demands. "I want you to depose the CEO of the insurance company," they insist. "I saw a lawyer do it on YouTube and he made the guy cry on the stand." The real-world lawyer then has the unenviable task of explaining that for a $5,000 soft tissue injury claim, not only is that legally impossible, but attempting it would be a sanctionable waste of the court's time that would actively harm their case. The client, instead of understanding, feels let down. They feel their lawyer isn't a fighter, like the ones they see online. The seed of distrust is planted, not by malice, but by a skewed perception of reality manufactured for clicks. This distortion creates a dangerous gap between public expectation and legal reality. And in the darkest corners of the internet, this gap becomes a chasm, a breeding ground for legal fantasies that can ruin lives. I'm talking about the sovereign citizen movement and its various offshoots. This is perhaps the most potent example of what happens when people trust charismatic online figures over the actual, established legal system. The ideology is complex and varies, but the core belief is that they, as sovereign individuals, are not subject to the laws of the United States government. They believe that if they just recite the right combination of magic words, refuse to acknowledge the court's jurisdiction, or file documents filled with bizarre pseudo-legal jargon, the entire system will be powerless against them. It's a fantasy, a legal fairy tale. But on YouTube it doesn't look like a fairy tale. It's presented with the appearance of authority. A confident speaker will stand in front of a bookshelf, citing obscure maritime law from the 18th century, misinterpreting the Uniform Commercial Code, and taking phrases from the Constitution wildly out of context. To someone without legal training, who is perhaps already distrustful of the government, it sounds compelling. It sounds like a secret key, a cheat code to beat the system that they've been given by a wise guru. The results are always, without exception, catastrophic. A person gets a simple traffic ticket. Instead of paying the $100 fine, they follow the YouTube script. They declare themselves a sovereign in court, refuse to recognize the judge's authority, and file gibberish motions. The judge, who has seen this 1,000 times, is not impressed. The $100 fine balloons into thousands of dollars in contempt of court citations. Their driver's license is suspended. A warrant is issued for their arrest. What began as a trivial infraction spirals into a life-altering legal nightmare, culminating in jail time and financial ruin. They followed the highlight reel, the promise of a gotcha moment against the system, and walked right off a cliff. They trusted the performance of law over the practice of it. But the distortion doesn't just affect individual expectations or lead people down dangerous rabbit holes. It has a much broader, more corrosive effect on our society. It's changing how we view the integrity of the entire legal system itself. This happens through the relentless politicization of legal analysis. When a high-profile, politically charged case hits the news, YouTube legal commentators descend. And the algorithm, as always, rewards the most extreme, most partisan, most outrage-inducing takes. Nuance is boring. Measured analysis doesn't go viral. A calm explanation of judicial precedent and the standard of review for an appellate court gets a few thousand views. A video titled "Activist Judge Destroys America with Shocking Ruling" gets millions. Slowly, insidiously, this reframes our entire understanding of the judiciary. Rulings are no longer presented as the result of a complex, often constrained, process of applying established law to a specific set of facts. Instead, they are framed as purely political outcomes. The judge wasn't following precedent. They were legislating from the bench to advance an agenda. The prosecutor wasn't weighing the evidence. They were engaged in a political witch hunt. Every legal decision is reduced to a simple binary: a win for our side or a win for their side. This teaches us to see judges not as impartial arbiters, but as political actors wearing black robes. It erodes faith in the very idea of a neutral rule of law. The concept that a judge might rule in a way that is contrary to their personal political beliefs, simply because that's what the law requires, becomes unthinkable to a huge portion of the population. They've been trained by the highlight reel of outrage to believe that law is just politics by another name. This is a profound and dangerous shift. A functioning democracy requires a baseline level of trust in its core institutions, especially the judiciary. It requires the losing side of a case to accept the outcome, not because they agree with it, but because they believe in the legitimacy of the process that produced it. When we lose that, when every court case is just another battle in a never-ending political war, the foundation of the system begins to crack. The spectacle, designed for online engagement, ends up undermining the very substance of the justice it claims to explain. So after all this, after seeing the good, the bad, and the systemic, is the answer to just unplug? To treat all online legal information as toxic and ignore it completely? Absolutely not. The genie is not going back in the bottle. This new media landscape is here to stay. The key isn't to reject the tool, but to learn how to wield it with precision, with wisdom, and with a healthy dose of skepticism. It's about learning to separate the signal from the noise, the education from the entertainment, and the analysis from the agenda. And in our final part, I'm going to give you the exact toolkit to do just that. This is the 5-part framework I use, and you can remember it with the simple acronym CLAIM. Because every piece of online legal content is making a claim on your attention and your trust. So let's break down how to evaluate that claim. First, C is for credentials. This is the absolute starting point. Who is the person speaking? Are they an actual licensed attorney? It sounds basic, but you'd be shocked how many legal commentators are not. A real lawyer will almost always be transparent about this. They'll state where they are licensed to practice. This isn't just a boast. It's a critical piece of information. Law is a licensed and regulated profession for a reason. Look for their name, the state where they are barred, and maybe even their bar number. You can then go to that state's bar association website. Every state has one, and look them up. It takes 30 seconds. Does their status say active and in good standing? Or does it say inactive, suspended, or disbarred? This is non-negotiable. If you can't verify their credentials, you can't trust their content as anything more than an amateur opinion. Also, what is their specialty? A lawyer who has spent 20 years in patent law might have a fascinating YouTube channel, but their opinion on a criminal procedure case is likely no more valuable than any other educated person's. Look for a match between their claimed expertise and the content they are creating. Second, L is for location. This is arguably the most important factor that separates general education from specific advice. The United States doesn't have one legal system. It has 51 major ones, the federal system, and one for each state. A rule that applies in California might be the complete opposite of the rule in Texas. A brilliant explanation of landlord-tenant law in New York is utterly useless and potentially dangerous if you're a renter in Florida. This is why you see that ubiquitous disclaimer. This is not legal advice, and for educational purposes only. It's not just a throwaway line to avoid liability. It is a fundamental truth. A good creator will constantly remind you of this. They'll say things like, "Now in my state of Illinois the rule is," or "This is a federal law so it applies everywhere, but your state may have additional protections." If a creator is presenting legal rules as universal truths without mentioning jurisdiction, that is a massive red flag. They are either being lazy or intentionally misleading. Always ask yourself, does this information apply where I live? If you don't know, you must assume it doesn't. Third, A is for agenda. Nobody creates content in a vacuum. Every single YouTube creator has an agenda. That isn't necessarily a bad thing, but you need to be aware of what it is. Is their primary goal to inform the public? Or is it to build a personal brand, sell a book, promote a course, or attract clients to their law firm? Is it to push a specific political ideology? Look for the signs. Do they have a link in the bio to a $1,000 masterclass on how to beat traffic tickets? Are their videos sponsored by a company that might have a vested interest in the legal topics they discuss? Does their analysis of a case consistently align with a particular political party's talking points, regardless of the legal facts? Again, having an agenda isn't inherently disqualifying. A lawyer trying to get clients can still provide excellent free information. A commentator with a political view can still offer sharp analysis. But you, the viewer, need to understand that agenda because it acts as a filter on the information you're receiving. It helps you understand why they are emphasizing certain facts and downplaying others. Fourth, I is for intent. What is the primary intent of the video? Is it designed to educate, or is it designed to entertain? The best channels do both, but one is always dominant. Legal entertainment often looks like this. Sensationalized thumbnails, titles in all caps with words like destroyed or exposed, and a focus on the most dramatic out-of-context clips from a trial. It's designed to get an emotional reaction, to generate outrage and clicks. Legal education, on the other hand, is often calmer. It focuses on explaining the why, the legal doctrine, the procedural rules, the historical context. It embraces nuance and complexity instead of running from it. It's the difference between a video titled, "Sovereign Citizen Gets Shut Down by Judge," and one titled, "Analyzing the Legal Flaws in the Sovereign Citizen Movement." The first is for entertainment. The second is for education. One tells you what happened, the other explains why it happened. When you're watching, ask yourself, am I learning about the legal system? Or am I just watching a highlight reel of courtroom conflict? Is this analysis? Or is it just outrage farming? Recognizing the intent helps you place the content in its proper context. Finally, M is for motivation. And this one isn't about the creator. It's about you. Why are you watching this video? What is your motivation? Are you a law student trying to understand a concept? Are you a curious citizen interested in a high-profile case? Or are you desperately searching for an answer to a serious legal problem you are personally facing? Your motivation fundamentally changes the risk profile of consuming this content. If you're just curious, the stakes are low. You can enjoy the drama, learn a few things, and move on. But if you are trying to solve your own legal issue, if you're thinking of using a YouTube video's advice in your own custody battle, your own contract dispute, or your own criminal case, the stakes are incredibly high. You are engaging in a form of legal self-diagnosis, and just like with medical information on the internet, it can be catastrophic. If your motivation is to find a solution to a personal legal problem, your answer is never on YouTube. Your answer is with a licensed attorney in your area. So that's the CLAIM framework: credentials, location, agenda, intent, and your own motivation. Run every piece of online legal content through that filter. To make it even simpler, here is a quick red flag checklist. If you see these, proceed with extreme caution. Guarantees. Any creator who guarantees a specific outcome is lying. The law is uncertain. No real lawyer ever guarantees a win. Absolutes. Language like "this is always illegal" or "this is never allowed." The law is a universe of exceptions and nuances. Absolutes are a sign of oversimplification. Emotional manipulation. If the video is more focused on making you angry, scared, or vindicated than on making you understand, its primary goal is not education. Lack of sources. A good educator will reference statutes, case law, or legal news. If they're just stating opinions as fact with nothing to back them up, be skeptical. Dismissing lawyers. Anyone who says you don't need a lawyer, just do this, is giving you profoundly dangerous advice. And selling one-size-fits-all legal documents or solutions. Your situation is unique. A generic form from the internet is often worse than nothing at all. Conversely, here's a green flag checklist. These are signs of a trustworthy, high-value resource. Transparency. They are upfront about who they are, where they're licensed, and their areas of expertise. Embracing nuance. They use words like "it depends," "generally," "in most states," and "a possible interpretation is." They explain the gray areas instead of pretending they don't exist. Citing sources. They show you the law they're talking about or link to the case documents. They show their work. Clear boundaries. They constantly remind you that this is education, not advice, and that they are not your lawyer. They actively encourage you to consult with local counsel. This is the hallmark of an ethical creator. They know their limits and want you to be protected. And finally, they focus on explaining the process and the principles. They teach you how to think about the law, not just what to think. So, after all of this, what's the final verdict? Can you trust a YouTube lawyer? The answer is yes and no. It's not a simple question because it's not a simple world. You can't trust them to be your personal attorney. You can't trust them to give you advice tailored to your specific, confidential facts. You can't trust them to represent you, to protect you, or to solve your problems. But you can trust them as a starting point. You can trust them to be educators, to be translators of a complex and often intimidating system. You can trust a good creator to demystify the law, to give you the vocabulary you need to have a more intelligent conversation with a real attorney. You can trust them to spark your curiosity, to make you a more informed citizen, to show you how the levers of power and justice actually work in our society. The goal of this journey was not to make you a cynic who dismisses all online information. The goal was to make you a critical, empowered consumer. The internet hasn't replaced the need for experts. It has just made the skill of identifying them more crucial than ever before. Use the toolkit. Apply the CLAIM framework. Look for the green flags and run from the red ones. Online legal content is a powerful tool. In the hands of a curious learner, it can build a foundation of knowledge. But in the hands of a desperate person, it can become a weapon of self-destruction. The difference is in the approach. So be curious, be skeptical, be informed, and when the stakes are real, close the laptop and call a lawyer.